Court does call the case of Harrison Cross Apartments versus Maya Pitts.
Good afternoon, Your Honor. David Tenant on behalf of Plaintiff. I think there's a second defendant there also.
Yes, there is. Matthew Taylor.
Hello, Your Honor. Matthew Taylor.
All right. Thank you. All right. Where are we on this case?
I had a chance to speak to Mr. Taylor a while ago, and the amount of rent that's owed on this case is $1,312.06. Court cost of $190 for a total of $1,502.06. We've agreed that that amount has to be paid by November 6th, 2025, or they could be evicted. I emailed copies to both Ms. Pitts and Mr. Taylor, and they both emailed me back, giving me permission to sign their name. And I did not have a chance to advise them of their rights under the court rule.
All right, folks, is all of that correct?
Yes, sir.
Yes.
All right. You didn't have any questions regarding the judgment at all?
No.
Well, you said, no. Did you have a question or you're good?
It just, so the court's, option for us is less generous than, what we already have signed. What is the court ruling if we did not sign with what we have?
And I was to enter a judgment today,
Yes, sir.
then you would have until the 3rd to pay as opposed to the 6th.
6th. Okay. Yeah. No, we're completely fine with the offer we signed with Mr. Fantero.
Okay, and it's so in that respect, it's more generous. Any other questions you have?
No, sir.
All right. I will grant a judgment to the plaintiff. That is by consent for possession. Redemption amount is in the amount requested or stated of $1,502.06 with a writ to issue November 6, 2025. Folks, I do have to advise you this is a consent judgment. You're unrepresented by counsel. You have 3 business days to think about it. If you believe that there's some legal reason, some confusion on your part, or some right you did not assert, you would have to file a motion with the court within that time frame. You understand that?
Yes.
All right, fantastic. Thank you. You guys have a great afternoon.
You too.
Court does call the case of J-Mar Realty versus Diane Joyner. And yep.
Diane's here.
Okay, there you are. Hello.
Hello.
All right. And where are we on this case?
I had a chance to speak to Ms. Joyner both last week and this morning, and we've come to an agreement. This is going to be a conditional dismissal. The amount of rent that's owed is $2,288.59. Court costs of $162 for a total of $2450.59. And what we've agreed is that starting in November 5th to be exact, she's going to pay her monthly rent plus $500, with the $500 being applied to the arrearage. And this will continue until the amount is paid in full. So basically 5 months. And that provided she does that, there'll be no writ, no late fees, and the 56-day rule is waived. I emailed a copy to her, and she gave me permission to sign her name to it.
All right. And ma'am, is all of that correct?
Yes.
Did you have any questions regarding the conditional order of dismissal?
No.
All right. So what the court will do is you'll have that over to us, Mr. Fantera, within 7 days?
Yeah, I'll have it over this afternoon.
Okay. All right. So that will come in. The court will enter the conditional order of dismissal along those terms. Ma'am, you are unrepresented by counsel. You have 3 business days to think about it from the time of our signing or my signing of the conditional order of dismissal. If you believe that there's some legal reason, some misunderstanding, or some non-assertion of a right that you have, you'd have to file a motion with the court within that time frame. You understand that?
Yes.
All right. Fantastic. Thank you. You have a great afternoon.
You too.
Court calls the case of Schooner Cove versus Tracy Ward.
Dave Singh for the plaintiff.
Tracy Ward.
Hi.
Hello.
She's here.
Hello.
Okay. So where are we on this?
You
You asking me, Your Honor?
No, I was asking Mr. Fink, and then
Oh, thank you. I don't want to, because I really don't.
you don't know, right?
Right. I'm like, I'm just all over the place. I'm sorry.
No, it's okay. Me too. Don't worry about it. Mr.
Mhm.
Fink,
3266.76.
I'm sorry. What was that amount again?
3266.76.
3266.76. Okay. And how were you intending on getting that paid?
Um, Actually, I just had surgery, and I'm on a bridge of getting paid. They have a bridge to like 2 weeks after surgery to pay us anything. I just got surgery on the 8th. I've been paying like since this happened like 700, 600. I've been trying to pay every time I get paid. It's just not equaling up and trying to catch up. Um, so yeah, that's where I'm at now.
Okay.
Yeah. So
And so
I'm
you guys weren't able to work out how this is going to get paid.
exactly. I'm just trying to I've been with them for 4 years now, so yeah. I'm just trying to keep up with the payments. It's been pretty hard, but I'm trying to stay afloat.
All right.
Trying to pay them.
And what is pain is pleasure in this case?
Right now I just had surgery with my gallbladder. I had gallstones, so I know they not concerned with that, but I'm trying to get on point once I get back. They said I can go back to work on November the 8th. But I'm still looking forward to keep on paying them and staying on float. It's just hard with the late fees.
I got you.
I mean, like I paid like 700, 600. Like it's just, and then it keep on going up.
Okay. And Mr. Fink, what's the landlord's preference?
Does she have an application pending?
From CSR, but not from SAR. They didn't want to even deal with me, but I'm waiting on for CSR to even say they wanted to even they
Okay.
saying yeah.
Is that through the county?
Yes.
Okay. So it would, if Amy tells, do you give permission for Amy to tell us if there's an application pending through the county, if she knows? Ma'am?
Yes,
Do you,
I don't know. I really
okay,
don't know.
but if you got an application through the county, do you give permission for Amy to let us know if that's the case?
All I know is that CSR said they would further investigate or see if I can be approved. But was it Star or that they denied me straight out?
Okay.
SOS denied me.
Who
Yeah,
did?
Hawk denied me.
Hawk
Yes,
denied you, so you don't
yes,
have an application through them.
no. So
Okay.
I had to
And
go
never
to
mind my question.
I have a application through SER DSS.
So you have something through DHS.
Yes.
Okay. How many people are in your household?
Right now, as far as my
I
But
need
as far
I
as
need a
my
number.
application on the rent is, I'm the only one. Right
Okay.
now,
So,
I have people that done got evicted from their apartment to live with me. We trying to rob
excuse
Peter
me?
to pay
What?
Paul.
What? Hold it. No.
No,
Yeah.
I know you don't want to hear that, but yep, this is
No,
that.
you really don't want me to hear
You to
that.
hear that? Yeah, I know, but yeah.
All right. So
Your
Peter to
Honor,
pay Paul. Yeah, I'm trying to stay afloat. I'm just
no,
trying to
I
like,
know,
yeah, nah, my baby
Miss
just got
Ward,
to.
Miss Ward, I hear you. I'm hearing
I'm
everything
trying
you're
to
telling me.
live. I'm
I know.
sorry, y'all.
I know. Mr. Fink, what do you want to do?
we come back in November, it's gonna be $4,500 and.
Right, but I can give her a week to try to work it out because she's supposed to get some
Yeah.
payment.
Either
So-
that or there's no triable issue, a judgment with a 17-day instead of a 10-day redemption period.
Okay, I can, and it's 3266.76.
3266.76, and that would make it the 10th.
Right. Okay, so Miss Ward, here's what I'm gonna do.
Uh-huh.
I'm gonna find no tribal issue after a hearing. I'm gonna issue a judgment for possession. But listen to me now.
Yes.
I'm gonna issue it for the 3266. Okay?
Okay.
66.76 is the total amount that needs to be paid. Normally you would have until the 3rd, but what we're gonna do is we're gonna give your writ date to the 10th of November for you to pay.
Okay.
Okay, so I'm giving out some more time. And the other thing, to help maintain your apartment, we're not including November in this amount right now. Okay, so it's probably a better way to go about doing it.
All right.
You got it?
Yes, sir.
All right, fantastic. Then I'll issue that judgment. And you have a good afternoon, Miss Ward. Feel better, please.
All right.
Thank you.
Thank you. Mine.
Oak Ridge Apartments versus Kiata Carter.
Good afternoon. Assumption Hart, P69542 on behalf of Plaintiff.
Wow, really? Wow. So hold it. You stop coming to my court too? No, I feel betrayed. I need to come over here more often on Wednesday and see exactly who's showing up. I feel like slighted. You're taking names now? All right, good. Make me a list, Ann. All right. How are you, Ms. Hardy?
I'm fantastic, Your Honor. How are you? It's so good to see you.
Well, thank you for that. I'm doing fantastic. Thank you. All right. And do we have Ms. Carter here?
She is, Judge. Have a consent judgment. Place the terms on the.
All right. Can you state your name?
I am Kiata Carter.
Okay. All right. And what are the terms of the consent judgment?
Judge, it's a consent judgment whereby rent to retain possession is $2,432. Court costs the amount of $175. Total redemptive amount, $2,607. I'll say that again, $2,607. With a pair vacate date of November 3rd, 2025. I did advise Ms. Carter of her rights under the court rules, and she did give me permission to sign her name to the consent judgment, Your Honor.
All right. Carter, is all of that correct?
Yes, I will actually be vacating the first of at the last day of October. So yeah.
Okay, gotcha.
Yep.
Okay. You have any questions regarding anything on that judgment?
No, sir.
All right. And you were advised of your 3-day rescission rights?
Yes.
All right, fantastic. Judgment to the plaintiff. That is by consent for possession. Redemption amount is in the amount requested with a writ to issue in 10 days. All righty, thank you.
Thank you.
All right. Oak Ridge Apartments versus Shaniri Moss.
Assumption Hart, 9542, Plaintiff.
Shaniri Moss.
All right, and where are we on this case?
We have a consent for this one as well, Your Honor. Rent to retain possession is $584. Court costs the amount of $175 for a total redemptive amount of $759. With the pair vacate date of November 3rd, 2025. Further orders, paragraph 10 indicates that $450 money order was given to the plaintiff today, and that will be credited to the amount in 2D once that has cleared, Judge. I did advise rights under the court rules, and she did give me permission to sign the consent judgment on her behalf.
Ms. Moss, is all of that correct?
Yes, I just have one question.
Sure.
The new manager said that he doesn't accept payments, so I would have to have everything in full.
That he doesn't accept partial payments?
Yes, that's correct. I'm sorry.
Okay, so I get that. A lot of places do that. I don't know why they do that. Does Judge Washington have a policy on partial payments? Because I have my own policy, but I'm covering for Judge Washington. I don't want to do much different. She doesn't have a policy on that? It's between them? Okay, so since Judge Washington doesn't have a policy, I'm going to order the plaintiff to accept her partial payment and credit it to her account.
Thank
so that
you.
she can get this paid. All right. It doesn't make any sense to me. If somebody's going to pay you money, just take it.
Yes,
But
thank
you're welcome, Miss Moss. I'm glad to see somebody agrees with me. Apparently, Miss Hart didn't. Anyway, all right. So Miss Moss, I'm gonna enter that judgment. Okay.
Okay.
And just try to get that paid, get everything paid by the 3rd.
Okay. Thank you very much, Your Honor.
Thank you. Miss Hart is like, wow, I just want out of here. He's crazy. Okay.
Judge Washington, Your Honor, I got tricked.
Wow. Wow. Really? Whoa. I got tricked. I wouldn't have shown up if I knew he was here. Wow. Okay. Oak Ridge Apartments versus Deborah Copeland Nash and Otha Nash.
Come to on behalf of Oak Ridge Apartments.
All right. What is plaintiff's claim, or where are we on this?
Judge, we have a consent here as well, Your Honor. Rent to retain possession in this matter is $3,749.44. Court cost amount of $214. Total redemptive amount, $3,963.44, with a payer vacate date of November 3rd, 2025. Your Honor, I did advise them of their rights under the court rules, and both of them gave me permission to sign their name to the consent judgment.
Okay, folks, is all of that correct?
Yes,
But we have,
we're waiting. Friends and Indeed are waiting to get this last judgment signed. And soon as we get it to them, they said it will be 3 to 5 days for them to help.
Okay, so you need the judgment signed, and then it's going to be 3 to 5 days once they get it, and then they can help out with this amount.
Yes.
Okay. And here at this court, you send the judgments over and they're signed today, right? So they'd be able to pick one up tomorrow?
Can we pick it today, later? Oh, it's already later, isn't it?
It is.
Yes, it is.
What?
Judge Washington generally says it is 10 days from the date that she signs the order.
Right, it is 10 days from the date she signs it. Right. Well, that's the law, but
Correct.
okay. You can probably, I'll sign off on these at some point, or she will. So you can probably pick it up tomorrow. I just call the court and check and make sure that it's done.
Okay.
Okay?
Yes.
All right. So I'll enter that consent judgment. Thank you very much, folks.
Thank you and have a wonderful day.
You do the same.
Thank you.
Oak Ridge Apartments versus Kamara Rucker
Assumption heard on behalf of plaintiff.
and Teresa Davis.
Hi, Judge Simpson.
Hello, Miss Davis.
Yes, Kamora is my niece. I'm not for sure why she's supposed. I guess because she's 18. She's my foster child, so she doesn't pay anything.
Got it. Okay. Okay. Very good. All right. So where are we on this case, Ms. Hart?
We have a consent judgment here as well, Your Honor. Rent to retain possession is $3,691. Court cost amount of $214. Total redemptive amount $3,905, with a payer vacate date of November 3rd, 2025, Your Honor. And I did advise her of the rights under the court rules. She gave me permission to sign the consent judgment on her behalf.
All right. Ms. Davis, is all of that correct?
Yes, I have a question though.
Go ahead.
My biggest question is that I put in a 30-day notice, and I just need to know that I can pay the money, but it's not going to do me no good if they're not going to accept the 30-day notice. And they're not responding to me about accepting my 30-day notice.
What 30-day notice?
I put a 30-day notice in to move from over there to move.
When do you want to move by?
I'll be out of there. I'll be out of there by Monday.
This Monday?
Yes.
Okay, so here's the deal. This judgment is only a judgment for possession. Meaning if you move, the judgment just sits there. If you want to then arrange to pay any back balance to them, then you can call the landlord and try to arrange to pay a back balance on a payment plan. But you don't have to come up with the money and move. If you're going to be out of there before the 3rd, then you're good.
So
that makes sense to you?
Yeah, it does. But she said that the judgment would go on my record.
It will.
It will go on my record on the 3rd?
Well, it will go on the record once it's signed. There will indicate that there's a judgment out there.
So my question, I guess, is
hold on. Let me find out what Judge Washington does, because I'm just telling you how it works at my court. And
okay, well, I might want to go to your court.
You might want to go to my court. No. Judge
only on Thursdays.
What?
Your tenant docket days on Thursdays.
On Fridays, but yeah.
So generally speaking, when there's a consent judgment, Judge Washington asks that it be added into further orders, that if it's paid timely or they vacate according to the order, that the judgment be set aside.
Okay. So here's what I'm going to do. Because this is, I guess, customarily what Judge Washington does. I would, under further orders provision, the court would indicate that what needs to be added is that if the defendant in this case vacates the premises prior to the writ date of the 3rd and or pays the judgment, that the judgment would be set aside.
Okay. So if I vacate, then the judgment won't go on my record. I can have time to pay it.
It'll be set aside.
Okay.
There's no money judgment on this. Okay. If you're worried about that's what's following you, there's no money judgment on it. This is just a judgment saying that there's an eviction. But if you move prior to the 3rd or pay it prior to the 3rd, the judgment will be set aside.
Okay.
You get that?
And then I'll have extra time to pay the monies.
You can call them and then arrange it. Okay.
Okay, so then there won't be a judgment on my record though, right?
The judgment that's on your record will be set aside. That is correct, ma'am.
Okay.
All right.
Thank you.
Thank you. Have a good afternoon.
You too.
All right. Bill, is that it for you, Miss Hart?
No, I've got 3 more.
I need to be real clear on what they're saying.
She's going to haunt me for 3 more.
If I
Bill Properties versus
I move,
Jessica Linton. Okay.
then this judgment won't go on my record. I have time to pay.
Miss Davis, you gotta do something. Okay, thank you. All right. Oh, she has to go back into her breakout room?
Yes, I have new people now who have appeared.
Oh. So, Ms. Hart, they've told me to send you back into a breakout room and never let you out. No, I mean, that's not what they said. Hold on. I got to get the message right. They said to put you into a breakout room because new people have arrived.
Judge, did it also say when Judge Washington will be back?
As soon as she can, but I'm going to tell her everything that you did to me. So you'll feel the pain. All right. So they're going to put you back into a breakout room, Miss Hart. Okay. Wow. Not shy about that.
We had Mr. Hicks was at the last hearing. He was disputing what was owed because of this is one of those where they were at an old building, and I think maybe you had handled it or went to circuit court maybe. But this is at a new property, and what he said to me last time was I think he said you told him not to pay rent. That's what I have in my notes. Because until the other case was resolved.
No, well, certainly I would not have said that the way they were coming down. He should have been paying rent either into court escrow or to his new landlord.
Right.
That's what I would have told them. And I don't think, I don't recognize this as any case, Ms. Weidling, that where the escrow was over at our court. I don't.
Yeah, I don't think so. And these are all charges from the new.
For the
license.
new unit.
Right.
Right. So, and part of the problem was, as I at least understood it, if they posted escrow at 14A court and then moved, right, because they really were going into the villas across the street, but that became Ipsy Township, that we would be transferring the escrow to their case. But we've only had one or two requests to do that from 14A and not on this one.
That's correct, and I do not have escrow for Mr. Hicks.
Okay, there is no escrow. We just checked we do not have any escrow for Mr. Hicks. So whatever your pleasure is, he's not here. You want to take a default?
Yes, please.
If you raise your right hand to be sworn, solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Go ahead. What is your claim?
Your Honor, this is a non-payment of rent case. I have that at this time, the past due rent is $5,202, and the costs are $175 for a total of $5,377. And we're asking for a default judgment for possession only, giving defendant until November 3rd to pay or vacate.
Judgment to the plaintiff, that's by default for possession, redemption amount in the amount requested with the writ issued 10 days.
Okay, I'll get that filed. That's the last one I have.
I did.
Thank you.
Thank you. Laurel Bay Apartments versus Anthony Tibbs.
Max Hillmood on behalf of plaintiff, Your Honor.
Anthony Tibbs. Anybody have him?
No, they're not present.
They are not present. Would you like to take a default, sir?
Yes, Your Honor.
Raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do, Your Honor.
All right, go ahead. What is your claim?
Your Honor, at this time, plaintiff moves for the entry of a default judgment. This case has been filed as a health hazard case. At this time, we're requesting an immediate order of eviction. The health hazard notice that was provided indicates that you have damaged the interior of the apartment, including setting fire to a bookshelf. You've also repeatedly damaged the blinds, causing them to be black, even after management has replaced them. There are additional violations in regard to disturbances, but the nature of the health hazard would simply be that initial indication of fire damage.
All right. And there was a request for an immediate writ other than statutory, but I think it's statutory, actually. Are you claiming there's a statutory basis for the immediate writ, sir?
Your Honor, would you repeat the question?
Is there a statutory basis for your request for an immediate writ? Because usually notice would have to be placed, but go ahead, sir.
Your Honor, my understanding was the nature of the health hazard case and the notice that was provided in regard to the health hazard would justify the immediate order of eviction. However, I'm not going to argue with you. If you tell me we're going to do the default 10 days, I'd be happy.
Yeah, I think that's what I'm going to do. Because even if there were, there's usually notice on there, and I was just looking to see if it was on the summons or not. I'll grant judgment for possession by default, no redemption amount, writ issue 10 days.
Understood. So that would set us at November 3rd that I'm adding into this default judgment, Your Honor.
Yes, sir.
Thank you, Your Honor.
Thank you. Lakeview versus Mariah, is it Nito or Burrito?
It's
Burrito. It's Burrito. I'm hungry. All right.
Good afternoon, Your Honor. Alex Chalengo, P87925 on behalf of the plaintiff.
All right. And your name, ma'am?
Good afternoon, Naomi Jaffe for Mariah Brito and Maureen Gorski. I'm a student attorney with Michigan Law Civil Criminal Litigation Clinic. My partner, Stratton Marsh, is also present today, and I'm supervised by David Santacroce. I would respectfully request permission under Michigan Rule 8.120 to represent defendants today.
Have you appeared before me?
I have not.
I didn't think so. Where are you from?
I'm from Virginia.
Oh, why are all these Virginians showing up? Where'd you go to undergrad?
I went to Cornell in Ithaca.
Oh, of course. So, but you started out in Virginia.
I did.
And they probably told you I'm a Maryland grad, so I don't like anything from Virginia.
I heard that on a prior call.
You were told that, right?
For what you said earlier.
Yeah. I'll try to be nice, but
I appreciate it.
I don't know how this is going to work. Virginia is that state that had to be divided between, and then they're just there. All right. Anyway. All right. Permission to practice is granted. We'll let you go ahead.
Thank you, Your Honor.
All right. Who's on the other side? All right, All right. Where are we on this case then?
Your Honor, after having opportunity to speak, I believe defense counsel has indicated that they will be filing an answer by the end of the week. So we would just ask for an adjournment to allow them time to file that answer and then know what the plaintiff is expecting to see regarding defenses.
All right. And so you're going to want 2 weeks out then? If that makes sense, November 5th as opposed to the 29th of October?
That makes sense.
That makes sense.
All right. We'll be adjourned to November 5th, 2025 at what time? 2:30. At 2:30.
Your Honor.
Yes.
We're also requesting limited discovery. We spoke
Of course
with,
you are.
with counsel.
Go ahead. I'm sorry.
No, that's okay. But yeah, we will be filing our answer by the end of the week. We're defending on grounds of breach of contract. In this case, my clients attempted to pay the full balance of rent, but were refused by plaintiff unless they also paid an over $200 court fee that was improperly added to their balance. And additionally, plaintiff has also been charging my clients with fees that appear nowhere in the lease. We spoke with opposing counsel briefly, and they agreed for limited discovery. My apologies, in this case.
See, this is what happens when you get these people from Cornell. They talk in all these big words. And, I'm just a Maryland terrapin. So we're just plain talk everything. I think I understood most of what she said, but okay.
My apologies, Your Honor.
No, I know. People try to use big words around this, but we get to the point. So what does Judge Washington do with limited discovery? Does she allow it? Okay, because I typically do not. All right, so I will let limited discovery occur in the case, especially since both parties have decided that that would be appropriate. Okay?
Thank you, Your Honor.
Thank you. All right, you guys take care. Lakeview versus Erica Carter.
Alex Schlengo on behalf of the plaintiff.
Erica Carter. Are they there? Turn on mute. Okay.
Hello.
Hello, your name?
Erica Carter.
Okay, there you are finally. All right, we got you. Where are we on this?
Your Honor, we have come to agreement on consent judgment. I have the total inclusive of cost of $3,202.97. Ms. Carter has agreed to pay this balance on or before the 3rd of November. And I have also advised of her rights under MCR 4.201J, and she has given me her permission to sign her name to the judgment.
All right. Ma'am, is all of that correct?
Yes, and also can I say something too?
Sure, go ahead.
So I'm just not going back to work off of a bad ankle injury. So my August rent, I paid a portion of which was owed $200, which I was trying to pay in September. I still have my cashier's check. They wouldn't take it for $1,670, and my balance due when the police officer came to my house to give me the paperwork for court, it says $1,625. So I went to my leasing office. They wouldn't accept it.
They wouldn't accept what?
My cashier's check for the $1,670.
Okay, you understand that you'll still owe the balance between the 32 and that, right?
Yeah, so at the time it was $1,625. So this was October 1st, so October 3rd, I told them I'll be back in to pay October, and she was like, no, you got to go to court first and pay everything, and
All
you're
right.
still.
So, ma'am, you still have the cashier's check that you talked about for the 16?
Yes.
Okay. Counsel, I'm going to order the plaintiff to accept her cashier's check for the 16.
Understood, Your Honor.
All right. And then you'll get this other part paid off by November 3rd, ma'am?
Yes.
Okay. That solved the issue for you?
Yes.
Okay.
And then she told me I was still like responsible for all the late fees, so I don't know if it's still some accruing right now or not, because they haven't been answering the phone.
Your late fees are going to accrue until it's all paid.
Okay.
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 But whatever cashier's check or whatever money, again, I don't understand why they won't take anything that you got. But
Your Honor, if I may.
Yeah, she told me they don't take partial payments, but I was like, in August I just paid partial because I literally just got back to work at the end of August.
No, I
And
got you.
She took it.
Okay. Yes, counsel. Do you want to tell me?
I was just gonna chime in that looking at the ledger, I believe that the court fee was the difference of why there was why there would have been a partial payment for that 1670 that she was willing to tender, just because that was the case already filed at that point.
Got it. I still don't understand why they didn't take her money, but that's just me. Maybe I'm greedy. I would have taken it. All right. Okay. Thank you, ma'am.
Well, thank you. Have a good night.
You do the same.
Thank you.
Court does call the case of Lakeview versus Karen Stratton.
Alice Jungo on behalf of the plaintiff.
Hello.
Hello, Ms. Stratton. Okay. And where are we on this? There you are. All right, where are we on this case?
Your Honor, we have come to terms of a consent judgment. I am showing a total inclusive of cost of $1,674.20. Mr. Ennis,
Give me that number again, counsel. I'm sorry.
$1,674.20.
All right.
That is inclusive of the court cost. Mr. Ennis agreed to pay this balance or vacate on or before the 3rd of November. I have advisory rights under MCR 4.21J, and she has given me permission to sign her name to the judgment.
All right, ma'am, is all of that correct?
Yes, sir.
All right, do you have any questions regarding the judgment?
No, sir. I'm paying it this weekend if I can make it to the bank.
Gotcha. Okay. Judgment to the plaintiff, that is by consent for possession, redemption amount, any amount requested with a writ to issue by the 3rd of November. All right.
Thank you, Your Honor.
Thank you.
Thank you.